Section 221 charge to state number 1 every charge under this code shall state the offence with which the accused is charged. Number 2 specific name of offence sufficient description if the law which creates the offence gives if any specific name the offence may be described in the charge by that name only. Number 3 how stated where offence has no specific name if the law which creates the offence does not give if any specific name so much of the definition of the offence must be stated as to give the accused notice or the matter with which he is charged. Number 4 the law and section of the law against which the offence is said to have been committed shall be mentioned in the charge. Number point what implied in charge? The fact that the charge is made is equivalent to statement that every legal condition required by law to constitute the offence charge was fulfilled in the particular case. Number 6 language of charge. The charge shall be written either in English or in the language of the court. Number 7 previous conviction when to be set out if the accused have been previously convicted of any offence is liable by reason of such previous conviction to enhance punishment or to punishment of a different different kind for a subsequent offence and it is intended to prove such provisions previous conviction for the purpose of affecting the punishment which the court may link fit to award for the subsequent offence. The facts, date, and place of the previous conviction shall be stated in the charge. If such statement has omitted, the court may add it any time before sentence is passed. Illustrations A. A is charged with the murder of B. This is equivalent to a statement that A's act fell within the definition of murder given in section 299 and 300 of the Pakistan Penal Code, that it did not fall within any of the general exceptions of the same code, and that it did not fall within any of the five exceptions to section 300, or that if it didn't fall within exception one or other of the three previous to that exception apply to it. BA is charged under section 326 of the Pakistan Penal Code with voluntarily causing grievous heart to beat by means of instruments for shooting. This is equivalent to statement that the case was not provided by section 335 of the Pakistan Penal Code and that the general exceptions did not apply to it. C. A is accused of murder, cheating, theft, extortion, adultery, or criminal intimidations, or using a false property mark. The charge may state that the committed murder or cheating or theft or extortion or adultery or criminal intimidation, or that he used a false property mark without reference to the definitions of those crimes contained in the Pakistan Penal Code, but the section under which the offence is punishable must in which in each instant be referred to in the charge. D. A is charged under section 184 of Pakistan Penal Code with intentionally obstructing a sale of property offered for sale by the law authority of a public servant. The charge should be in those words. Section 222. Particulars as to time, place, and person. Number 1. The charge shall contain such particulars as to the time and place of the alleged offence and the person, if any, against whom, or the thing, if any, in respect of which it was committed, as are reasonably sufficient to give the accused notice of the matter with which he is charged. Number 2. When the accused discharged the criminal breach of trust or dishonest misappropriation of money, it shall be sufficient to specify the cro- gross sum in respect of which the offence is alleged to have been committed, and the dates between which the offence is alleged to have been committed, without specifying particular atoms or exact dates, and the charge to framed shall be deemed to be a charge of one different offence within the meaning of section 234, provided that the time include between the first and last of such dates shall be exceed 1 year. Section 223. When manner of committing offence must be stated. When the nature of the case is such that the particulars mentioned in section 221 do not give the accused sufficient notice of the matter with which he is charged, the charge shall also contain such particulars of the manner on which the alleged offence was committed, as will be sufficient for that purpose. Illustrations. A. A is accused of the theft of a certain article of a certain time and place. The charge need not set out the manner in which the theft was effected. B. A is accused of cheating B at a given time and place. The charge must set out the manner in which a cheated B. C. A is accused of giving the false evidence at a given time and place. The charge must set set cut that the portion of the evidence given by A which is alleged to be false. A is D. A is accused of obstructing B, a public servant, in the discharge of his public functions at a given time and place. The charge must set out the manner in which A obstructed B in the discharge of his functions. E. A is accused of the murder of B at a given time and place. The charge need not state the manner in which A murdered B. F. A is accused of disobeying direction of the law with intent to save B from punishment, the charge must set out the disobedient charged and the law infringed. Section 224. Once in charge taken in sense of law under which offence is punishable. In every charge, words used in describing an offence shall be deemed to have been used in the sense attached to them, respectively, by the law under which such offence is punishable. Section 225. Effect of errors. No error in stating either the offence or the particulars required to be stated in the charge, and no omission to state the offence or those particulars shall be regarded at any stage of the case as material unless the accused was in fact misled by such error or omissions and it has occasioned a failure of justice.